Hey everybody, good afternoon. Depending on where you're at, it's another Zenny 62 on YouTube show that also goes to Oakland News Now and the other blogs in the Zenny 62 Media Network. It's my pleasure to introduce David Smith of Manat. He is the attorney for the Oakland Bulk and Oversized Terminal Organization. Dave, great to have you here. Technically, great to have you back, but in a somewhat different view. Yeah.
Thanks for having me, Zenny. Happy to be here.
Got it. The Ninth Circuit Court decision is now history and much talked about. What are your thoughts?
Excuse me. It's exactly as we expected it to be. The district court did a very thorough analysis of the situation involving the terminal, and the city of Oakland found the city of Oakland's process to try to undo it to be a complete sham, and issued a very detailed decision as to how he found that. And as we fully knew they would, the Ninth Circuit upheld that decision.
What was the main reason, in your view, the Ninth Circuit came to the decision they did?
That the city of Oakland City Council is not above the law. And they've been told that in several occasions of late, unfortunately. What happened with the terminal is it was approved by the city council in 2013 pursuant to a development agreement, a freely negotiated development agreement by which the city and the residents of Oakland were huge beneficiaries by the provision of jobs, committing to jobs programs to an unprecedented manner, prioritizing the hiring of local West Oakland residents, not using a prior criminal record against workers in the hiring process, tremendous environmental benefits by shifting the transport of goods from the diesel trucks that idle in the neighborhoods of West Oakland to rail, the best technology of rail, by the way, and tremendous revenues to the city in the form of rents for the land, as well as a slice of the revenues from the operations of the terminal. And that was all agreed to in 2013 and granted vested rights, which is not uncommon at all for a project of the scale. And lo and behold, a few years later, when the Sierra Club showed up with a political campaign against council members, potentially, they decided they weren't going to enforce their own law, adopting the terminal and going to try to block it. You can't do that.
Something, and people who watch this know that Inside Terminal Solutions is one of my clients, and I'm very proud to say that. It, among other things, is a great weapon against those people who feel like they're always finding something and playing the 20th century version of media, which I detest as the 21st century. But that said, what I find really fascinating about all this is the court finding that the city admitting themselves, the court said, well, it's obvious the city of Oakland knew something about coal being involved in the project, which runs completely counter to what Barbara Parker would say. We didn't know until 2015. I thought, come on,
That's been one of the most frustrating misrepresentations, frankly, in this whole thing, is that somehow they were duped. The record itself shows just the opposite. One, the comparable facilities that they were looking at and investigating whether the city wanted a bulk terminal all shipped, and the vast majority of the product being shipped worldwide were fossil fuels at that time. And the city's own analysis from later, it's called the long-range management plan, prepared by the city's own attorneys, internally defined a bulk terminal and said it's a facility that ships things like lumber, sulfur, and coal. Presentations made in the context of the vetting of possible projects going on out here all included video and pie charts type analyses of the bulk commodity market and what's being shipped. It was just not, and as you said, the Ninth Circuit itself recognized that the city was provided the information of what this facility was. Bottom line, as we've said all along, they knew very well in 2013 what they were approving. They granted it vested rights, and when it became politically uncomfortable, the 2015-2016 city council thought they could just undo it and disregard their own laws. The development agreement, Zenny, I keep saying laws because under state law, the adoption of a development agreement has the full force of law as with any other ordinance the city passes. And when the city passes a law, future city councils don't get to unilaterally exempt themselves from it.
something else too that I find bothersome about this, and like your view, is that I go all the way back to 1991 with the port's call for a bulk terminal, and the 1996 San Francisco Bay Area Seaport Plan pointed to the need for a bulk terminal. In fact, 7 new berths. They said between 3 and 7 new berths of bulk terminals, acknowledging that the Port of Oakland was the best siting for them and the Oakland Army Base area. We have all of this material that anyone can look up online or go to the MTCA Bag Library if they're of a mind to do so over in San Francisco. It used to be in Oakland, and learn this. And yet with all of that, I don't understand why the city of Oakland believes suddenly that it can craft a fib. Okay. And I'll take that. I mean, I've got enough business insurance to wear that, but that's what it is. And I say that, Dave, because I have ample after ample example on video of where we had to break because someone wanted to change what they were talking about the project when they were with the city of Oakland.
The project as proposed had universal acclaim to the degree that the state of California backed the project itself with a grant of $275 million, I believe. That was because of the modernization of the transportation methodologies and how it would work, that it was connecting the transport of commodities via rail, again, which would result in tremendously better environmental consequences for West Oakland by moving things via mostly high efficiency locomotives, as opposed to 18-wheelers spewing diesel particulate matter in the community as they've grown used to. And the BACMed, Bay Area Air Quality Management District, also gave a grant. And the OBOT, the developers of it, have already used that money to obtain the most highest technology efficient locomotive for use in this facility. And it's just sitting out there because the city of Oakland will not even process permits. A fence permit has been lingering. The Bay Conservation and Development Commission issued a permit before the city of Oakland could on this, and they're just refusing to do it because they want to ignore what the federal court has told them, which is that their actions in this regard violate the law.
I wrote a piece that basically asked the question, how much of this was the city of Oakland's ego against Phil Tagami? How much of this is something like that? Because it seems to defy common sense, the city's behavior.
Well, it's just interesting, isn't it? How the politics of personal destruction, how everybody goes after Phil. This project, when proposed, was the child of a multi-conglomerate of corporate interests, of public interests. It was the state of California, it was the city of Oakland, it was the Port of Oakland, it was everybody rallied around it, approved it as presented, which is exactly what's being proposed to be built out there. And now all of a sudden it's Phil Tagami duped the world. That's quite a compliment to Mr. Tagami if he can pull the wool over everyone's eyes in that regard. And again, now my understanding that the state money's been spent and the state is wondering where it was spent and where's the terminal that they helped fund.
Also help me clear out something, because there are people who are under the impression that Phil found coal. I keep explaining to them that Phil didn't find coal. The city of Oakland found it and put it in the Tioga report. And the Tioga report, if anybody bothers to read it, basically sets up something that I've seen Phil go through for a long, long time. This narrative that Phil can't do it.
And this whole notion, frankly, Zenny, is just a red herring. Coal terminal, not coal terminal. It is a bulk commodity terminal. And a bulk commodity terminal will operate over greater than 50 years, probably. I think the agreement is for 66 years. That's a generational project which requires investment of tens of millions of dollars on the front end. Nobody's guaranteeing or wanting to guarantee the shipment of any single commodity. They want to guarantee the shipment of what the market demands to be shipped so that it's a viable enterprise. At the time the project was approved with vested rights by the city council doing their due diligence, bulk commodity shipments across the world, maybe 40 to 50% were fossil fuels. The amount of that goes up, goes down, again, depending on market demand. The operator of the terminal, at this point, the subtenant is proposed to be ITS, again, is reflecting what the market is demanding to be shipped throughout the world. And that will stay true throughout the life of this facility. As the demand shifts, the facility will adjust to be able to move what the market's demanding. That's been the plan all along.
Also, and I'm glad you said that, a number of people in Oakland seem to think, at least on the no coal in Oakland side, which I think is, I've given them the name no coal in Oakland, but trucks blowing smoke are okay. But at any rate, they seem to think that the domestic coal market is the target because they keep saying, well, coal is on the decline, when in point of fact, coal consumption worldwide is actually on the increase because of growth in Asia. It's crazy that people just don't understand what it is they're talking about, huh?
Well, I love the concern for the economic well-being of the development, that somehow they know better what is appropriate fiscally and economically than the developer. And the city of Oakland, like we said back in 2013, did their own fiscal due diligence. You referenced the Tioga report. That was the whole point of that, is this, because it's not just the developer, again, the revenue, the city gets a cut of the revenues of this. Now, if it fails, the developer is the one that fails. But if it thrives and succeeds, then the city of Oakland participates in that success. And the viability of it, the market demand for it, is well known to the developers and their subtenant. And again, it's not about one commodity or another. Once the investment is made on the front end to this facility, it ensures that the facility can safely and productively move according to what market forces demand.
Also, what are we looking at in terms of how many people have already been employed? Because some people talk to me about employment on the back end, but quite a few people have been employed already, right?
They have, but they're not at the moment. With the construction work, and these things are approved in at least two phases: one, construction, and then operation. Some of the terminal has not been constructed, but the infrastructure on the ground to prepare the site for the terminal and the rail servicing have largely been done, and there were strict parameters put on that in terms of hiring, in terms of wages, in terms of organized labor, union affiliation, all of which were more than exceeded according to unprecedented commitments on the front end. And the same will be true of the terminal itself.
Where are you all with the city right now? There was talk, not by the city itself, but by a Mau, if you will, that this person, although they didn't put it that way, wanted the city to just simply craft another coal ban. And I'm thinking, wait a minute, the city has already spent, what, I think $10 million in legal fees? Something like that? And
it's also unfortunate. Nobody wanted lawsuits. Nobody wanted litigation. The city gave us no choice but to stand up and insist that they honor their commitments and obligations as conveyed in 2013. And the litigation continues on. Our organization stands ready on the steps of City Hall to engage in productive dialogue all along, as we always have, to find a path forward and get this project back on track for the benefit of Oakland residents, Oakland workers, and Oakland coffers, the revenues from the project. The longer this goes on, the more the city exposes the city, not only deprives it of the benefits of this project, but further exposes the general fund and attorneys. It's just very unfortunate. We just want to move the project forward.
Hey, isn't there another danger too in terms of, right now, and this seems to be forgotten by some parties, but we're in the middle of a pandemic, and it's had a tremendous impact on supply lines throughout the world. What you have are 6 states in the middle, roughly in the middle of the country, some in the West, that really would love to have a pipeline to Asia for their coal mines, and those areas in Asia would love to have them. And it's, from what I've read, that need is actually more acute during a pandemic. Now, I know that there's this story that because of the pandemic, renewables have overtaken traditional, but that's in the United States. Okay. And I emphasize that to people listening or watching. That's in the United States, not the whole world. And it's very important to understand that differentiation. Even then, United States is one of the top 5 coal producing countries in the world. How long can the city of Oakland sustain its position before it attracts the attention of authorities even higher than the state of California, if you know what I mean?
I do, Zenny, and everything. Wouldn't dispute anything you said, and we do know that all the way up to Washington, the Department of Energy is aware of this facility and others, and view it as a very essential facility for national security and energy reliability. You know, I would say, like I said, I don't disagree with anything you said. I think there's plenty of people in Oakland or elsewhere who could raise a very contrary public policy argument that they embrace, that, okay, and I'm not going to tell them that their position is invalid. What I am going to tell them is where I started, which is Oakland is not above the law. And they don't get to pick and choose which laws they want to enforce and which ones they want to ignore just because of political pressure and expediency. They made this agreement, the city council, in 2013, and the 2016 council, 2020 council, does not get to just disregard it. And they will bear the financial consequences of refusing to honor and abide by their commitments if they're unwilling to do so.
Dave, I know you're a busy man with a busy schedule, and I want to thank you very much for your time. Stick around in the room. But thank you so much. And everyone, thank you for watching Zenny62 on YouTube. We'll be back with more. Big day, big news, lots going on. Just be safe, be careful, and be mindful of your fellow person. All right.
Thanks.
Stick around.